first I want to give you just a little overview of where we get our cases. We have cases coming out of Pearsall, which is the detention center in Pearsall, Texas, about 2.5 hours away, unfortunately, driving. Those are folks detained by the Department of Homeland Security for various violations of the immigration laws, and some are just recently arrived here in the United States. Some have been here a while and have criminal grounds of removability or maybe have overstayed a visa and had the bad luck to be picked up at a traffic stop, and the police call their buddies, the immigration officers. So what we do is we do have a contract with the Executive Office for Immigration Review, which is the immigration courts, to do a presentation, a legal orientation presentation. That's what Benny does a lot of. I do those as well, and also Griselda, another of our employees who's a BIA accredited representative. In other words, basically can do all the functions of an attorney in immigration law. So we do have a lot of detained clients. We also have clients that are detained, women who are detained in Hutto or Taylor, Texas. Those folks are usually Natalie's the one who encounters them there. She does an orientation program there. And we have fabulous volunteers also who will bring cases to our attention from the detained context. We also have non-detained cases, which are basically folks who just walk through our door and come in for a consultation. And those are generally, well, maybe affirmative, maybe defensive cases. So maybe folks who have come here either lawfully or unlawfully to the United States, and now would like to apply for asylum either before a judge if they've been apprehended by immigration, or affirmatively if they have no immigration history. So that's where we encounter clients, and I would like to kind of put in a special plug for the people who are detained, because it's really hard to get pro bono attorneys for them. And what'll happen quite often is, we don't have the resources to take all the cases, all the asylum cases we see, certainly not in Pearsall. And there's a huge need. There are also many people who are in detention who are bond eligible, but just don't have somebody to do a bond hearing for them. So it may be that if you take a detained case, you may be able to secure the release of your client. You may not be able to, because some people may not be eligible for bond. And I won't get into the specifics of bond eligibility, but a detained case may become a non-detained case. And a non-detained case may become a detained case if your client gets apprehended during the course of your representation. So, if you have time and you don't mind doing a little driving, it would make all the difference in the world to somebody's life if you could take a case out of Pearsall or Taylor, Texas, Hutto. So basically, asylum law arises out of the 1951 UN Convention relating to the status of refugees, and the definition of a refugee basically tracks the language of the convention. In order to qualify for asylum, the applicant must establish that they've either been persecuted in the past or have a well-founded fear of future persecution on account of one of 5 protected grounds. And you'll hear us go through these grounds repeatedly: race, religion, nationality, membership in a particular social group, or political opinion. So there has to be a nexus between the harm that the person has either suffered in the past or the person fears and one of these 5 grounds. So somebody who has a fear of a personal vendetta, or crime in general, or fear of the very real risk of poverty if they go back, would most likely not have an asylum case. It is a discretionary form of relief, so asylum, you may actually prove up your case, and the judge may decide that in their exercise of discretion, or the asylum officer in the case of an affirmative case, the adjudicator may decide that in their exercise of discretion they do not want to grant relief. So in order to qualify for asylum, you must meet the definition of a refugee. And basically the difference between a refugee and an asylee is a refugee is someone who is encountered outside of the United States and brought in and basically adjudicated to have this fear before they enter the United States. An asylee is someone who arrives here and then it's determined that they're a refugee. So It's anybody who is outside their country of nationality, who's unable or unwilling to return to or avail themselves of protection of their country because of the persecution or well-founded fear of persecution on account of those 5 grounds. And we'll get into those 5 grounds more specifically. There are a few bars to asylum, and one of them is a frivolous application. A frivolous application is a really specific thing. It's basically, it's in the case where a material element of your claim is deliberately fabricated. So if any material element of your claim is deliberately fabricated, it's frivolous. So frivolous doesn't just mean a weak case. It essentially means that there's something made up about it. And if you are found to, or if a judge decides that you have made a frivolous application, you are permanently ineligible for any other immigration benefit. In the context of either affirmative or defensive cases, the adjudicator has to give the frivolous warning, and then if the person proceeds and makes a frivolous application, then there's this permanent bar for any immigration benefit. So if in the context of immigration court, for example, if the judge never read the frivolous warnings, then the person, even if they've made a frivolous application, is not subject to ineligibility for other immigration benefits. But obviously this should not come into play in your cases. If you have a sense that your client is making something up, or if it doesn't really add up, you definitely want to get really familiar with the person's facts, and then also with what you know to be the country conditions. So persecution, there's actually no definition of it, but basically it's the infliction of suffering or harm upon those who differ in a way that is regarded as offensive. So persecution, there are a lot of cases that say things like persecution is not mere discrimination. You know, if all that the person fears is, let's say, being fired from a job, and that without more is probably not persecution. The persecution doesn't always necessarily involve violence. It can involve threats, very serious threats, and basically all that is defined by case law. It does have to be, the takeaway from this is it does have to be serious harm that your client fears. So threats to life or freedom, physical abuse can definitely constitute persecution. Generalized climate of criminality or civil strife is not enough to constitute persecution. And you want to really pay attention to this because persecution, a finding of past persecution gets you a rebuttable presumption of a future fear of persecution. And that's what you're trying to prove. In order to win an asylum case, you have to show that your client has a reasonable fear of persecution, a well-founded fear of persecution. So, you know, the persecutor also has to be a state actor, or if they're not a state actor, a person or group that government is unable or unwilling to control. So here's some examples: guerrilla forces, death squads, dominant clans, paramilitary groups, groups tolerated by society at large. You know, and it may actually even come down to an individual persecutor if that person is supported by the society at large. So you'll see that in domestic violence cases. There is, you know, Matter of RA is a case that basically changed the particular social group for women who are in a domestic relationship that they cannot leave that is abusive. If the government is not going to help, if the woman, particularly if she approaches the police and no help is rendered, then even though the persecutor is really, in that particular instance, just her husband or her domestic partner, that still may be persecution as long as the government is unable to, or unwilling to control it. So basically for asylum, there are different levels of relief. Asylum is the best persecution-based relief you can get because at the end, if you win asylum, your client is eligible after a year to apply for permanent residence. and then 5 years after that for citizenship. So they're basically on the road to citizenship if they win asylum. I will also go through withholding of removal and relief under the Convention Against Torture, which do not provide as good a benefit if you win. So in order to win asylum, you must show a reasonable possibility that the person will be persecuted, and it's often framed as a 10% chance. So you don't have to show that there's, the person will absolutely be persecuted. It just has to be a reasonable possibility. And in fact, in some cases, you're not even required to show that your client would be singled out if you can show a pattern or practice of persecution of persons similarly situated. Even if your client can't show that they in particular would be persecuted, if they're from, for example, a particular social group that is so hated in their society, they may be able to make out a pattern and practice case. So there's a subjective and an objective component to this. You have to show actual fear, which is important because if your client, and you see this sometimes with people who maybe have competence issues or maybe they're mentally ill and that's the basis of your claim. If your client says they're not afraid, it's going to be really difficult to point out. They have to have subjective fear. They have to feel afraid. They also have to have an objective fear. In other words, you have to present facts, you have to present country conditions, documents, sometimes expert opinions, or other proof that would indicate that's indicative of a situation in which a reasonable person, any reasonable person, would fear persecution in that situation. If you guys have any questions, you can go ahead and interrupt. Yeah.
Going back to frivolous,
Yes.
does it have, are you saying it has to have something false, not just weakness or something?
Right.
So if we had someone, say from northern Mexico, that had a violence problem, we kind of stretched to make that the facts are all true, but you kind of stretch to make it an asylum claim, that's not a frivolous filing?
Right.
Okay.
Right. A weak case is not a frivolous case. That's why I think frivolous is a little bit of a misleading word, because it sounds like you're talking about a weak case, but really what frivolous is, it's defined in the regulations as a material part of it being made up.
You said a generalized climate of criminality wasn't a sufficient basis for persecution, but if you have, like a complete breakdown of order, like these cartels and some countries, drug cartels and violence and are militias, and the government isn't in a, they can't do anything about it, or they're bought off by corruption, is that sufficient?
You've got to show either past persecution on the basis of one of the 5 grounds: race, religion, nationality, social group, or political opinion, in that individual person's case. Or you've got to show that they've got a well-founded fear of a particularized harm to them. So no, and it's really tragic because all the time in Pearsall, in the detention center, I ask people if they're afraid to go back, and they say, yeah, well, actually, I borrowed money from the Zetas narco-trafficking gang in my hometown, and they will kill me if I go back. And unfortunately, there's a lot of really bad case law on gang cases. The way I think of it is, with regard to the cartel cases, especially in Mexico right now, which is an incredibly dangerous place, and people are probably getting killed on a daily basis after being deported there. There's a lot of really bad case law where it seems like maybe the sort of jaded view of it is that courts are very reluctant to open sort of these floodgates to people who fear drug trafficking gangs coming into the country and getting asylum, particularly people who've been involved in the gangs themselves in the past. So there's a number of different ways those cases tend to get denied when people apply for asylum based on fear of gangs. One is social visibility. Is sort of a subset, and we're going to get a little bit more into a particular social group, but pretty often when you're doing a gang case, you want to make it, really the only way to do it would be to say that your client is a member of a particular social group, such as somebody who has provided information to the police leading to, say, let's say, the arrest of a member of a gang, and now the gang in retribution wants to go after your client. Informing on a gang, on a drug cartel, does not make you a member of a particular social group, according to some case law out of, that's sort of had to do with Colombian drug cartels, but those are very, very hard cases to win.
I mean, just, you're talking about the drug cartels and everything, but if it was,
You're talking about, so
if it's sectarian or ethnic
you
type
have a
of
much
thing,
better time.
that's a better case.
Absolutely. So if you're talking about Somalia, where there's the government has basically lost control and there's a certain sense of lawlessness, and maybe a dominant tribe would persecute you because of your membership in a different tribe, that usually has an ethnic component, race, or you can even say it's similar to a nationality type of argument. You would have a much better time.
Let me just ask one more question. If
Sure.
you're like in northern Mexico and then it's a whole village that's involved and there's, families that are involved, that doesn't qualify?
That's a really good question. You have to be really artful about how you frame that nexus between the persecution and one of the 5 grounds. Family, in some cases, can be a social group, but there's some bad case law recently out of the 5th Circuit saying that family will not constitute a particular social group if the only reason you're being persecuted is to get at another member of your family. So, for example, if a gang wants to get at your father because they want to punish you and they're saying, I'm going to kill your father to punish you, that would, although that's a family relationship, that wouldn't constitute a particular social group. So there are some cases in which a family, yes, can be a particular social group, but it would be hard to make out with a gang-related case from northern Mexico. Yeah, unfortunately. You see, and that's the sort of the crazy thing about asylum, is that there are all kinds of harm that can befall people if they return home that really isn't cognizable under the asylum laws. So, past persecution, if you can make a case that your client has suffered persecution in the past, it triggers a presumption of future persecution. And that's really the ticket. If you have past persecution, the government is going to then have to go back and rebut the presumption, and it's fairly difficult for them to do that in many cases. They have to either show a fundamental change in circumstances in the country, or like the end of a civil war, for example, or something like that, or the possibility of internal relocation in that country. I realize, Jane, you had a question, and I jumped over you. Now,
No, I
got you at a bad time, sorry.
It was just on the point about somebody has to have an actual fear or show. So if somebody was just seems so somebody's incompetent, but their grounds are very well able to be established. You still, but they're just for some reason not capable of understanding the danger.
It's tough. I think in a situation like that, what you would want to do is try to get some kind of guardian ad litem or some kind of guardian in place. Those are not going to obviously be provided by the court, but you can make a motion requesting that, maybe get a family member who is competent to look out for that person's best interests. And there are, it is possible in some cases for mental illness to constitute a particular social group, but that's a challenging situation where your client says, I'm not really afraid, or so when you're presenting your case, one of the initial things that you do in immigration court is when you're taking pleadings in an asylum case, you decline to designate a country of removal. Because in every removal case, one of the first questions the judge asks is, if in the event of your removal, what country do you wish to go to? And the person has to decline to designate. Or they can designate, another country, but that's kind of difficult unless they have some kind of legal status there. So you'll run into people like in Pearsall in detention who are very negatively affected by detention, and they'll say, well, I want to apply for asylum, but if it's going to take a long time, I just want to get voluntary departure. Because to them, the persecution that they fear is maybe on a par with the persecution that they perceive it is to be in detention. you know? But you want to be careful, if your client says something like that in court, it's going to undermine their subjective fear. Any other questions at this point? Okay, so if DHS successfully rebuts the presumption, they can still be granted asylum if they can demonstrate compelling reasons for being unwilling or unable to return, either arising out of the past severity of past persecution or a reasonable possibility of suffering other serious harm. So an example of this is if you have, let's say, female genital mutilation case, and you have shown that the person has been persecuted in the past and it actually has been performed on her, then if you have a particularly distasteful government attorney, they might argue that that harm is not likely to befall that person again. But you're probably still going to win on the severity of the past persecution, even though it can't actually physically happen again. The severity of that type of persecution should, you know, preclude the DHS from rebutting your presumption. And other serious harm can be completely unrelated to the persecution. So if there's, I don't know, if you have a case, a Haitian person, and then you can show that there's a cholera epidemic, so even though maybe their fear, you know, on one of the 5 grounds is no longer valid because of a change in circumstances, if they're going to go back and they're going to die of cholera, that may be sufficient to then basically still be granted asylum even though the presumption's been rebutted. Internal relocation is often an issue in these cases, and you want to sort of craft the theory of your case and the questions you ask your client on direct around this question, because it almost always comes up in every case. So basically the government attorney will always ask your client on cross-examination, well, couldn't you just go, like, for example, if you have someone from Mexico who's transgender, male to female, and they'll say, you should go live in Mexico City, they have gay marriage there. You basically have to show why that's not really feasible, or why in your client's particular case, you know, that really is a meaningless change. And so you probably want to ask those questions of your client before the government does if you're in court. You know, literally ask your client, why couldn't you just go live somewhere else in your country? Go ahead.
But the reason you couldn't live somewhere else doesn't have to have a nexus to your asylum case. Could it be you don't speak the language in that part of the country?
It could be, yeah, that's right, yeah. The reason could be, I mean, you have to show that it's really impossible.
Right.
But yeah, it can be other things. So these are some of the factors, geographical limitations. I mean, sometimes you've got a person who's from a very small country, and that comes into play, you know. And then conversely, like if you have somebody from India, we were recently in a case, in a hearing where, you know, the government said, quoted the population of India and said, okay, among like however many people there are in India, couldn't you live somewhere undetected by, you know, your husband's family or whatever. But then that's when you you rebut that. You basically show the social or cultural constraints of the caste system, the impossibility of the idea of a woman living alone in India, and various other factors. And that's just the internal relocation. That's like an important thing to highlight, because you may have all your ducks in a row and have proven your case except for internal relocation, and that's a basis of denial, potentially.
Excuse me.
Yes.
How do you know what some of the factors are in a particular country that support that person's inability to go back to another part of the country? Do you rely on what that person tells you, or what resources are there to find out?
An excellent question. Expert opinions are really good, especially if it's a case where it's an unusual claim, or you know the judge hasn't heard many of these, or, you know, basically in any case where you can find an expert opinion, you should use that, or use an expert opinion. And quite often we rely on professors, anthropology professors, you know, people who have written books or articles academically on the country or on that region. And we look for people who have recently traveled to the country or have extensively lived there, because, you know, obviously that bolsters their expert status. So expert opinions are very important. Country conditions documents. The U.S. State Department releases a human rights report, a country conditions report on every country basically every year. And you want to be very familiar with that because often those are really not that helpful, but if there's something in there that says that supports your case, you definitely want to highlight that and bring that to light because the judges put a lot of stock in what the U.S. government puts out. But yeah, experts, documents, and testimony, and your own client's testimony as well. You can also present other witnesses in immigration court. You can present family members or neighbors or other people who know people who have gone back that are similarly situated, who have been persecuted or haven't been able to relocate in that case. So the basis of persecution, as I mentioned, I can't say it enough: race, religion, nationality, political opinion, and social group. You've got to develop your theory of a case, and if it's a social group, you've got to be able to essentially name that social group. So, for example, homosexual men with a female sexual identity, gender identity, something like that, something very specific. And you want to be able to frame your whole case around that idea because if you fail on developing a particular social group, then you could lose the case on that basis. You have to show the nexus between the past or feared persecution and one of these grounds. And Real ID, I'll talk a little bit about Real ID. It basically changed two kind of important things. The Real ID Act gave a new standard for the nexus because in many cases there are more than one motive. There's perhaps a racial and a political opinion component to a case. Before Real ID, it was certainly customary and possible to have a mixed motive case. And now what we're talking about is the motive of the persecutor. Now after Real ID, one of these grounds for asylum has to be at least one central reason for the persecution. So you have to basically pick your strongest nexus and really go for it there. And it's fine to also bring evidence of other reasons for the persecution. But just be aware of the at least one central reason standard. The other big change, it wasn't actually really a change, but the Real ID Act kind of codified the way evidence is received. As you might imagine, people fleeing persecution quite often don't have any documents. They might not even have a passport or any form of identification. And it is still possible to make out a case, and even after Real ID, it is still possible to make out a case. But with regard to credibility, and I'll just read this, the immigration judge must weigh the applicant's credible testimony along with other evidence and can require corroboration unless the applicant does not have the evidence and cannot reasonably obtain it. So if either the judge or the asylum officer says, you say you went to the police, I think that you should present the police report. And I'm going to require that. They can go ahead and require it. And then if you can't get the police report, then you have to basically show why it's not possible, why your client cannot reasonably obtain it. So one of the first things you want to do when you first meet up with your client is ask them, what documents can you get to substantiate your claim? So, from even their identity is a big thing with Real ID. Real ID is interpreted by the government attorneys to be DHS attorneys to require evidence of identity, and that's not really what it says. But it's going to make your life a lot easier if you can get the person to get a birth certificate or some photo ID or something like that. And if they claim to have called the police, ask them for the police report. If it's not going to put somebody in danger, go get it for them. And if they can't get it, you want to know why not, and you want to get good testimony on the reason. Okay, so the basis of persecution, race would include ethnic groups, religion is fairly self-explanatory. Nationality can overlap with citizenship, ethnic, linguistic group. On the application for asylum, there's basically there are the boxes for the basis of your persecution, and you may have one or more boxes checked off. Political opinion, it includes actual and imputed political opinion. So it doesn't necessarily mean that somebody has to be like a card-carrying member of some kind of political organization in order to win the case. And in 1996, Congress, so we have coercive population control measures in China, and if you're able to prove that your client was subjected to them, then you have established the nexus between the persecution and the political opinion. Questions?
Is there ever a thing where they can say, yeah, maybe you have that political view, but you don't have to express it, and nobody would know political views, but you just stay quiet?
No, I mean, basically, you're not expected to,
You're not
essentially,
expected to change your behavior.
you don't have to change your
Right,
behavior.
persecuted. Okay.
Yeah, if it wouldn't be reasonable to change, if there's, it's kind of like with the social group definition, if it's something that you shouldn't be expected to change,
Mhm.
then no. I mean, essentially, if you hold a political opinion, and you can prove that you hold it, you can prove that you'll be persecuted on that basis, whether or not you could stop expressing it is not an issue.
Or change your mind.
Or change your mind, yeah. So the particular social group, that's sort of like, the vessel into which all theories can be poured. It's basically persons of similar background, habit, or social status. Matter of Acosta basically describes it as a common or immutable characteristic. So, family can sometimes be a basis, a particular social group. Gender, sexual orientation, class background, maybe caste, things like that. The bars to asylum eligibility. If you're a persecutor, you would be subject to the bar. And while that might sound a little bit far-fetched, you actually do have the government raising that issue quite a bit. It was something that came to light a lot in the 80s, with the civil wars in Central America. It was not always clear who was a persecutor and who was feared persecution. And then also material support is another one. I don't know if it's on here. If you're a material supporter of to terrorism, then you can be denied asylum. So you want to ask your client if they've ever been a member of a group that basically was opposed or persecuted people based on their race, religion, nationality, or social group. You want to find that out. And sometimes it's kind of subtle and difficult to show. I mean, basically, like if you've got a Nepali case and they were forced to pay money bribes to the Maoists, you want to show that they weren't actually a member of that group, but they were forced under duress. Firm resettlement in another country is basically it's not enough to have been a refugee who temporarily resided in another country, but if you were able to live and work and perhaps own property in a third country. So let's say somebody passed through, let's say somebody from Afghanistan passed through Iran and they lived there for a while and they worked, but they were basically undocumented, then you could probably rebut this, any kind of firm resettlement claim. If you, for example, go to Canada and become a landed immigrant, or whatever the equivalent of permanent resident is there, and you could go back to that, you're not going to be able to get asylum in the United States. So you also want to pay attention to other nationalities that your client may have. If they have more than one nationality, you're going to have to actually show that they have a reasonable fear of return as to both countries. So, which, you can sometimes do. We recently had a case of a transgender, male to female transgender person who feared return both to Cuba, where she was born, and to Nicaragua, where her mother was born and where she spent most of her life and could have returned as well. And we're successful in that. Conviction of an aggravated felony or a particularly serious crime is a bar to asylum eligibility. And basically a particularly serious crime is a crime, fairly severe crime, basically against a person. If somebody's got a record of DUIs or theft or even potentially drug possession, those are probably not particularly serious crimes. If they've assaulted someone or kidnapped someone, those are more likely than not going to be particularly serious crimes, and that's either in or outside of the United States. Serious non-political crime outside, oh, that's actually the wording for the outside of the United States, but the analysis is similar. If they pass through a safe third country which has an agreement with us, only so far Canada, then that's a bar to asylum eligibility. So in other words, the person, if they first hit Canadian soil, they're required to apply for asylum there first. And you see that actually in reverse. A lot of times you'll see folks coming up from the Mexican border into the United States so that they can get to Canada, to their family that may already be there, and they may have a really good asylum case, and they've got to now litigate that in the United States. They can't just go to Canada. Yeah.
Do you have any examples that, was more than 1 year of the last entry?
Yeah, that's, let's see, there you go. Oh wait, that's withholding.
I saw, it was the,
Where's the 1 year? Oh yeah, failure to file within 1 year. That's actually a really big one that I just skipped over, thank you. Basically, you cannot apply for asylum unless you file within 1 year of your last entry to the United States. There are some exceptions to it though, such as if you have other legal status. So often somebody will come in on, let's say, an F visa as a student, and then they'll want to apply for asylum. And as long as they were in valid status, they have to apply for asylum within a reasonable period after the expiration of whatever status they have. So, reasonable period, we always define it as like as soon as possible, as soon as you can physically like put it together. But yeah, so basically, other exceptions would be incapacity, legal incapacity, like mental illness, things like that, or changed country conditions. So if you come to the United States and you're just living your life, and then all of a sudden there's some terrible change in circumstances, some kind of coup in your country, then that might also toll the 1 year. Is that what you're looking for? Yeah. And that's a really, really big one, because a lot of times when we give you a case, we're going to say, oh, look, here, you want to take an asylum case? We'll call it an asylum case, but really they've missed the 1 year deadline quite often, and it'll be a withholding or removal case, which I'm about to get to. Because if you can't get around the 1 year, and that's a really tough thing. Basically, if you can't get around the 1 year, then you're no longer eligible for asylum. And even if you can make that a case, and when you're withholding a removal case, that person's never going to get their green card, most likely. And they won't get to bring their family to the United States either, just for missing that 1 year deadline. Terrorism or danger to the security of the United States. So withholding is for folks that are more likely than not that their life or freedom will be endangered. So it's basically, the way to think about it is it's essentially the same exact framework as asylum, but there's more like a 50% chance that they would be persecuted if they were to return. So there's a higher burden. You have to show there's more of a possibility that they would be persecuted, but it's on those same 5 grounds. And you also get the past persecution, which triggers a presumption of future persecution. There's no 1 year deadline for filing. The crime bar is a little different. An aggravated felony is only a bar to withholding of removal if you got a sentence of 5 years or more and you served at least 5 years in jail on that crime. And so you can, there's some crimes that might not bar you for withholding, but would bar you for asylum. Limited benefits. You can never get your green card, at least through this form of relief. You don't get derivative status for your family. You lose status if you leave the country, but you can remain in the U.S. and work legally. So whenever possible, you want to try to make your client eligible for asylum, obviously. Withholding, when you win withholding, you actually do have an order of removal against you. It's just withheld. And if the government can then prove that conditions have changed in your country, it's possible they would send you back in the future. And you have to renew your work permit, so it's, you have to be, it's a more tenuous position to be in. The Convention Against Torture is basically an international agreement that no one will be returned if they're going to be tortured by their government. Doesn't have to be for any particular reason, as long as the government is going to torture you. And it does have to be a state actor or someone working very closely with a state actor of their acquiescence. So, if you're afraid that you're going to be tortured for, I don't know, you'll be sentenced to death because, you're gay in Iran or something like that, that would be a Convention Against Torture case. More likely, you'd of course want to try to get asylum, but you can simultaneously apply for asylum, withholding, and Convention Against Torture. It's all on the same application. So, you might as well do that. Because if you win Convention Against Torture, it's similar to asylum withholding, that basically you don't get a green card, you only get to stay in the United States. There is a deportation order lurking in the background. Torture. Torture is a really specific thing. It has to be an intentional act. It has to inflict severe pain or suffering by or sanctioned by a public official, and they have to be under the custody or control of the offender. And the severe pain or suffering is serious business. The former Bush administration had a torture memo that I think you may all have heard of, and it basically parsed the definition of torture and said, well, if it's fleeting, even if it's really painful, it doesn't constitute torture. But hopefully we're not working with the same restrictions. But basically it has to be in custody. For CAT, there's a more likely than not standard, so you have to show there's a very high possibility that you're going to be.
Sarah has a question.
Oh, I'm sorry.
On the last slide, the very last sentence, applicant must be under the control or custody or control of the offender. Well, the applicant presumably is here. So,
Yeah, at the time they were being tortured.
okay.
Yeah. So it's perspective only. Unlike asylum, you don't get a presumption of future torture if you've been tortured in the past, but it certainly is good evidence, and all evidence must be considered. So we've talked a little bit, mostly I've been talking in the context of defensive asylum cases because those are most of the cases that I do, and that's a good portion of the cases that we give to pro bonos as well. If it's affirmative, basically the client is in the United States but has not yet been placed in removal proceedings. They may have some other lawful status, but basically when we say they're not in the immigration system, we mean they're not in immigration court. You file the affirmative application within 1 year. This is like the most important thing. If you're a pro bono and you have a client who has not yet filed for asylum and they have arrived, recently, you've got to file that within a year. That's a huge red flag. Mark that on all your calendars. Get them filed within a year, or else they're not going to be eligible for asylum. So then what happens is you go to the Houston Asylum Office for an interview. Once you file the application, you give a notice. You go to that interview, and right there, the asylum officer, or you might get a written decision, but occasionally they'll do it right, they'll grant right then. You get a grant, a denial, or referral to immigration court. So if it's denied, it is referred to immigration court. And basically then you have another shot at it. You can go back to the immigration, you can go to the immigration judge and apply again for asylum de novo. Defensive asylum. So defensive asylum can arise either because you filed an affirmative case and you lost and now you're in proceedings, or defensive asylum could be that you got put in proceedings for some other reason, like you got caught at the border and you're in immigration proceedings and you've got to file in front of the judge. The charging document in immigration court is a notice to appear, and the same rule applies with regard to applying within 1 year for asylum. Master calendar hearings are preliminary hearings in immigration court, and you have to file your application for asylum in open court and in a master calendar hearing. And then once you do that, the judge will set you for a merits hearing or individual hearing. And that's when you present, your expert, you have 15 days before your final hearing to submit all your documents. Hopefully you'll write a nice brief, and that's where the decision is made. Immigration judges quite often make decisions from the bench. Not always. They may just say they're going to issue a written decision. A lot of times it depends on how close it is to 5 o'clock in the case.
Burge,
Yes.
can I ask a question? What happens if I get a pro bono case assignment and my master calendar hearing is set after my client's 1-year deadline?
Good question. It's almost like you wrote a plan. You do a motion to advance so that you can have, and for the reason that your client will no longer be eligible for the benefit, if the master calendar isn't advanced, and you attach a copy of, or the original of your application for asylum, and you make sure you get that date stamped, so that even if the judge denies your motion to advance, you have a date stamp from the immigration court showing that you filed that application before the 1-year deadline. And hopefully the judge will grant your motion to advance. Depends on the judge. So, okay, so we'll talk a little bit about procedure